be treated with kid gloves.
I talked to 3 national security lawyers who deal with this for a living. I mean, this is all they do today. And they all said, without exception, there's no question this person would have lost her clearances if this were a senior GS 14 or 15 employee, probably would have lost his or her job and possibly would have already been indicted.
Judge Andrew Napolitano is our Fox News senior judicial analyst. Do you agree with that?
I do. I would actually go a couple of steps further than Steve and suggest that Mrs. Clinton should be consulting very high-powered national security criminal defense lawyers, that is, criminal defense lawyers who have national security clearances so they can see the evidence against her, to negotiate with the FBI, because the case against her is overwhelming, damning, and from her perspective, grave. And when she says there's no there, when she laughs about it, when she says this is the re-suggesting of an old New York Times story, she's effectively mocking the 100 FBI agents that are investigating her.
Even today, she said that she never sent or received classified information.
That infuriates me, Megan, because that's a word game when she says, I neither sent nor received anything marked classified. I'm making the quotation marks with my fingers, because nothing is marked classified. It is marked confidential, secret, top secret. And under top secret, there are 4 sub-markings, the most sensitive of which is this select access privilege, which is what 24 of her emails had on there. That is the most secret information the government has.
But unlike David Petraeus, her supporters are saying she didn't willingly, she's not being accused of willingly sharing this information with people. That's what he did when he gave this information to his biographer. And so if she was merely negligent in not protecting it, criminal charges?
Absolutely. I happen to think that intent should be an element of criminal charges. That's just me. This particular law expressly says intent is not an element, meaning the government doesn't have to prove that she intended. Her negligent treatment of national security secrets, her failure to safeguard and store national security secrets
on a server that the Russians and the Chinese may have hacked into.
Correct. Can be the basis for a criminal prosecution. We're not talking about one. We're not talking about a loose leaf in a desk like General Petraeus. We're talking about hundreds.
They're saying 2 things tonight. First of all, they're saying they think that this Inspector General for the intelligence community who is Obama's appointment, is in cahoots with the Republicans to hurt her with leaks. And secondly, they are saying this stuff that we're all treating as like so scary, it's stuff that could have appeared in a newspaper, that the CIA would treat classified information as classified, even like if it's about a drone strike and it appears in the New York Times, but it's also in her email, they'd say that's classified.
There's a bona fide argument to be made that the government classifies too much information, but not at the SAP category. That is the highest level of classification. Do you know what type of information is in there? The names of moles, black ops, that is, secret programs that the government wants to deny the existence of. For her to have put that on an open server while she's the Secretary of State is absolutely grossly negligent and must be the basis for an indictment.
It's getting more